Good day, everyone. I'm Zeline, and today we will explore two more constitutional rights that empower every one of us to decide where to live and how far we can go or travel. So, to start, let's check the source. Article 3, Section 6 of the 1987 Constitution, it provides that the liberty of abode and of changing the same within the limits prescribed by law shall not be impaired, except upon lawful order of the court. Neither shall the right to travel be impaired except in the interests of national security, public safety, or of public health as may be provided by law. So this section outlines two distinct but related rights and their permissible limitations. So it sounds straightforward, right? But within this short section lies a careful balance between freedom and responsibility. So let's break down the two rights to understand it better. So first, we have the liberty of abode. So the liberty of abode is defined as the right to decide where one wants to reside. And the term abode, it refers to residence or domicile. So this right is a fundamental guarantee under the Section 6 of Article 3 of the 1987 Constitution. And like many constitutional rights, the liberty of abode is not absolute, and it is subject to specific limitations. So these limitations are twofold. So it can be impaired within the limits prescribed by law or by the Congress or upon lawful order of the court. So a common example of a court order limiting abode is a probation order. So let me show you an example of a probation order. So this is an example of a probation order, but let us first define what is probation. So the definition of probation in the Presidential Decree number 968 or Probation Law of 1976 is defined as a disposition under which a defendant, after conviction and sentence, is released subject to conditions imposed by the court and the supervision of the probation officer. So, meaning lang yan, instead of going to jail, the court allows them to stay out of prison, but under certain rules. And one of the rules or conditions set by the court is like this one, number 3, condition in the example probation order that we have in front of us, that he shall reside at Purok 6, Barangay San Vicente, Banga, Province of South Cotabato, and shall not change his residence without prior approval of the court. So, ayan, limited ang kanyang liberty of abode. And now, let's shift to the right to travel. So more than a plane ticket or a road trip, it is your constitutional freedom to move, explore, and connect. So whether you're crossing islands or crossing borders, this right is protected. But just like liberty of abode, it comes with limits. So for the safety of the nation and the welfare of the public. And the right to travel is also a guarantee, of course, of the Article 3, Section 6 of the Constitution. So it is considered fundamental right because it is essential for individuals, to access and exercise their other rights, such as the rights to education, free expression, assembly, association, and religion. And the Supreme Court has repeatedly emphasized that the right to travel is not merely about physical movement. It is essential because it enables individuals to access and exercise other fundamental rights. So, diba, this freedom of movement is necessary to access places of education, attend religious services, participate in assemblies, join associations, and express oneself in public forum. So, if a person cannot travel, mabablock ang ability nila to do those that I have mentioned. However, The right to travel is not absolute. The Constitution explicitly provides the conditions under which it can be impaired. So it can be impaired in the interest of national security, public safety, or of public health. And the Constitution adds the requirement that such impairment may be provided by law. So this legal requirement is significant because it was purposely added to prevent excessive restraints on the right to travel by administrative officials who might be tempted to wield authority under the guise of these interests. So there must be an explicit provision of law or the rules of court, I'm sorry, for to provide for the impairment. And now, the next question that we need to answer is, who are those that can restrict the right to travel? So there are three primary bodies that can restrict the right to travel. So first, we have the courts. They can restrict the travel of individuals who are out on bail or on probation. So if a person is on probation, one of the conditions of the probation is that the probationer shall secure the written permit to travel from court. So hindi lang liberty of abode niya ang limited, pati ang kanyang right to travel. And syempre for those on bail, this is described as discretionary, particularly if they are deemed a flight risk. So when we say flight risk, it means a person is likely to run away or hide to avoid going to court or face punishment. So we will discuss this further later with a few cases that we have. And then next, executive and administrative officials. So they can impose restrictions if they act non-arbitrarily, provided there is a law authorizing them, and the restriction is based on national security, public safety, or of public health interest. And of course, Congress, yes, the Constitution makes it clear by just reading it that the Congress can restrict travel because it says there within the limits prescribed by law. So, since I mentioned earlier, the courts can restrict the right to travel, let's dig deeper to their inherent power, particularly in issuing whole departure orders. So now, despite the wordings in the 1987 Constitution textually suggesting that only Congress can limit the right to travel as provided by law, the Supreme Court has consistently held that courts possess the inherent power to issue whole departure orders. But first, by the way, let's define whole departure order. So this is a court order that commands the Bureau of Immigration to prevent a person from leaving the Philippines. And an HDO is typically issued after criminal informations are filed with the court. That is because the court now acquires jurisdiction over the case and the person of the accused at that stage after filing the information. Now the court views it that they can issue HDO without a specific law or any mention in the Constitution giving them that power. It is considered innate and essential for courts to perform their judicial functions effectively, protect their jurisdiction over a case and accused, and ensure the due administration of justice. So this inherent power exists simply because the court exists. And this is now an example of a whole departure order. So this was issued by Regional Trial Court for Edgar Matobato and his co-accused. So remember nyo pa ba si Edgar Matobato, yung self-confessed hitman and whistleblower who claims to be a member of a Davao death squad. So he was charged of kidnapping a suspected terrorist, Salim Moktoum, and was issued a whole departure order. So it includes the name of the accused, the charge or violation, the date of birth, and the address of the accused. So usually, dapat naka-indicate din dito ang passport number sa whole departure order. Pero this one, wala kasing passport na naka-register under the name of Edgar Matobato sa system ng VFA. Even his biometrics, no? Not on their system. Kaya wala ditong passport number. And now, um, posting of bail and restriction on travel. So, um, when an accused post a bail, they are granted provisional liberty, but they also voluntarily submit themselves to the jurisdiction of the court. So this submission necessarily carries a restriction on their right to travel. And the condition of bail requires that the accused be available whenever the court requires their presence. So therefore, a person that was released on bail does not have an unrestricted right to travel, and it requires a court's permission to leave the country. So the court's power to prohibit a person admitted to bail from leaving the Philippines is considered a necessary consequence of a bail bond. And the issuance of a whole departure order naman in such cases is a process that complements the granting of bail, and serving as a notification to the Bureau of Immigration that the accused should not leave the country without the court's permission. Because syempre, allowing an accused facing criminal charges to leave the country without the court approval would effectively render court orders and processes ineffective. But remember, okay, while courts have this power, their discretion to deny travel must not be arbitrary and must balance the accused's rights with the need to maintain their jurisdiction. And this was explained in the case of C versus Sandigan Bayan. So in this case, si C, he was charged with a violation of Anti-Graft and Corrupt Practices Act, or RA number 3019, and upon posting a bail, a whole departure order was issued against him. So si C dito filed multiple motions for an allowed departure order to travel abroad for business and family reasons. And he also offering to post a bond and submit his itinerary and hotel bookings, but all his motions were denied by the Sandigan Bayan. Now, the Supreme Court held that an accused who posted the bail and is on provisional liberty and is now requesting permission to travel has the burden to show the need to travel, but permission should not be unduly withheld if it is sufficiently shown that allowing travel would not really deprive the court of jurisdiction over their person. So, sa case na to, may grave abuse of discretion sa part ng Sandigan Bayan for denying C's motion to allow him to travel, kasi C has always been traveling for work and for family even before the case was filed. And though his last name is C, tunog Chinese, his birth certificate clearly indicates his Filipino citizenship. So while the courts have the power to restrict travel, through actions like issuing whole departure orders or denying motions for permission to travel abroad for those on bail, this power is not absolute and must be exercised judicially and not arbitrarily, because a court's denial of a request for permission to travel is still subject to judicial review on the grounds of grave abuse of discretion. So now, is it only RTC that can issue whole departure order, or is it only courts that can issue whole departure order? So the Sandigan Bayan, a special court tasked with hearing and deciding cases against public officers and employees involving graft and corruption, has been specifically confirmed to possess this inherent power to issue whole departure orders. Now, in the case of Garcia versus Sandigan Bayan, the Supreme Court clarified that the Supreme Court Circular number 39-97, which provides guidelines for regional trial courts issuing HDOs, limiting them to criminal cases with penalties over 6 years of imprisonment, does not exclude other courts like Sandigan Bayan from exercising their inherent power. And this circular purpose was to actually prevent indiscriminate issuances by RTCs, and the distinction was based on the gravity of the offense. So, kumbaga, this is just to regulate the issuance of HDO by the RTC para sa criminal cases na ang penalty is over 6 years of imprisonment, and not on restricting the inherent power of other courts with different jurisdiction for issuing such orders. And the same principle of inherent power of a court like Sandigan Bayan was held in the case of Pichay versus Sandigan Bayan, no, who has charges for violations of banking laws, graft and corruption and malversation. Mga criminal cases ito, no? So, the Sandigan Bayan, by virtue of its inherent judicial power, can validly issue whole departure orders as necessary means to ensure its jurisdiction over the accused and the case is effective. And such HDOs constitute a lawful limitation on the constitutional right to travel. Now, as I've mentioned earlier, executive and administrative officials can restrict the right to travel provided they act non-arbitrarily. There is a law authorizing them and the restriction is based on national security, public safety, or of public health interest. So in short, the power of the executive and administrative officials to restrict the right to travel is limited. And the major case addressing this is the case of Genuino versus Honorable De Lima. So this case challenged the constitutionality of DOJ Circular Number 41, which allowed the DOJ Secretary to issue HDOs, watch list orders, and allow departure orders. So the Supreme Court declared DOJ Circular Number 41 unconstitutional, and the court found that there was actually no law that allowed the DOJ to restrict one's right to travel. And that general provisions in the administrative code that outlines the DOJ's purpose and functions were not sufficient to grant them such power. And a fundamental right like travel, it requires a specific enabling law. Dapat specific siya na para talaga siya to restrict the right to travel, by the administrative agency. And the court stressed that administrative bodies, unlike sa courts, na meron na talagang power to issue HDOs, and it is inherent and essential for their function over cases already filed. Ang administrative bodies naman, they require specific statutory authority to curtail fundamental rights. And also, the DOJ, hindi nila pwedeng gawing rason or they could not justify the restriction based lang sa need na ang accused daw need ang presence in preliminary investigations, because preliminary investigation do not require the accused mandatory attendance. And the prosecutor's investigatory power is inquisitorial siya, but it does not embrace the power to impose restraint on the liberty of movement. And following the case of Genuino, the Supreme Court addressed the need for a judicial mechanism to prevent individuals suspected of a crime from fleeing during the preliminary investigation stage. So yung mga under investigation pa, para clear na what can be done for those persons para hindi sila basta-basta makakaalis. So this led to the promulgation of the Rule on Precautionary Whole Departure Order. So the PHDO, this is a court order commanding the Bureau of Immigration to prevent a person suspected of a crime from leaving the country to evade arrest and prosecution. So it can be issued ex parte by the regional trial court. So it is applicable in cases involving crimes where the minimum penalty prescribed by law is at least 6 years and 1 day, or when the offender is a foreigner, regardless of the imposable penalty. So now, ano kaya ang common denominator ng mga cases na na-mention ko, by the way? So they are all criminal cases, So meaning the whole departure order is only applicable to criminal cases and hindi siya applicable to civil cases. So now, paano ba mag-apply ng PHDO sa court? So the prosecutor will file an application with the proper RTC, and upon motion by the complainant and the preliminary determination of probable cause by the investigating prosecutor based on complaints and attachments. And the PHDO shall only be issued upon the determination by the judge that probable cause exists, and there is a high probability that the respondent will depart the Philippines to evade arrest and prosecution. So the judge must personally examine the applicant and the witness under oath. And however, the judge finding of probable cause for the issuance of the PHDO is solely based on the complaint and attachment. And it is specifically for the purpose of issuing the PHDO. So this finding of the judge no is without prejudice to the prosecutor's final resolution of the criminal complaint after the preliminary investigation. And the PHDO, hanggang kailan siya valid? So, valid siya until lifted no, by the issuing court as warranted by the result of the preliminary investigation. And ano naman ang pwedeng gawin ng mga naisyuhan ng PHDO? So, yung mga respondent na naisyuhan ng PHDO, they can file a verified motion to temporarily lift the PHDO. And on meritorious grounds, syempre. And it will require a bond para ma-lift. I mean, temporarily lift, sorry. Now, this is an example of a precautionary hold departure order. So, just like hold departure order, it includes the name, date of birth, address, and passport number if meron. So, this was issued to Kapa Ministry with their leader, Pastor Joel Apolinario, and other members of the ministry. And so, ito ang precautionary hold departure order. And we already discussed na the right to travel or outbound travel. But now, what about the right to return or inbound travel? So while the right to travel protects the right to leave the country, there is a related but distinct right, and that is the right to return to one's country. So this right is not found no in the Bill of Rights of the Constitution, but it is recognized as a generally accepted principle of international law. So both the Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights guarantee the right to live and return to one's country. So this right was the central issue in the case of Marcos versus Manglapos. No? So this case dealt with former President Ferdinand Marcos, the late Ferdinand Marcos, and his family being barred from returning to the Philippines after being deposed. So the president at that time, no, Cory Aquino, cited potential threats to the national stability and security if uuwi ang Marcos family dito sa Pilipinas. And since the Constitution is silent on who can restrict the right to return and no law explicitly determines this, the court concluded that it logically falls under the President's residual powers. So therefore, the President, as a steward of the people and the defender of the Constitution, has the duty to protect the general welfare and keep the peace. And in exercising these powers, the President can balance the general welfare and common good against individual rights and can prohibit return if it possesses a serious threat to the national interest and welfare. So, I already mentioned that freedom of movement is not absolute. And we already have an idea what will happen when public safety, national interest, or a global health crisis enters the picture, right? So, let's now explore the consequential limitations that remind us even our most valued rights comes with necessary boundaries. So, limitation of movement can also arise from laws or government actions and those that don't directly target the right to travel but have consequential effects. So, the case of Spark versus Quezon, this case examined the local government curfew ordinances for minors. So the court applied here the strict scrutiny test because the right to travel is a fundamental right. So it held that an ordinance can validly restrict the right to travel for minors through curfews based on delegated legislative power to local government units. And the ordinances served a compelling state interest, such as promoting juvenile safety and preventing juvenile crime, as the state acts as parents patri, no, or guardian of persons under legal disabilities such as children. However, the restriction must also satisfy the least restrictive means or narrowly drawn requirement, meaning that the law or ordinance should only limit uh, rights as much as necessary to achieve its goal. So, if there are other ways to achieve the same goal that would restrict the people's rights less, the government should use those instead. Now, in contrast, in the case of Zabal versus Duterte, this case concerned the temporary closure of Boracay Island by presidential proclamation for rehabilitation. So, the petitioners argued that this violated the right to travel, no? Hindi na sila makakaswim-swim doon sa Boracay. So, the court ruled that this was not a restriction on the right to travel, and any impact on the right to travel was just merely consequential, no, to the closure that is necessary for rehabilitation, and it was just temporary. So the proclamation was focused on rehabilitation and not directly impairing the right to travel. So remember guys, no, the right to travel cannot be invoked when a government action does not directly impair it, but just a consequence. Now, I also mentioned, no, the right to travel can be restricted within the limits prescribed by law. So there are several specific laws that provide for restriction on the right to travel, typically justified under the constitutional exemptions of national security, public safety, or of public health. So we have here the Anti-Terrorism Act of 2020, no? Section 34 of this law allows the court to issue PHDOs or HDOs against persons charged with terrorism, even if out on bail, and may limit their travel to within the city or municipality where they reside or the case is pending, in the interest, of course, of national security and public safety. We also have the Philippine Passport Act of 1996 or RA 8239. This allows the Secretary of Foreign Affairs to authorize consular officers to refuse, restrict the use of, or withdraw a passport of a Filipino citizens for reason, of course, of national security, public safety, or of public health. We also have the Anti-Trafficking in Persons Act of 2003, under which the Bureau of Immigration may offload passengers with fraudulent travel documents, doubtful purpose of travel, or possible victims of human trafficking. So, di ba, kung kaduda-duda ang mga galawan mo doon sa airport, ma-offload ka talaga. And we also have the Migrant Workers and Overseas Filipinos Act of 1995. This allows, or as amended by RA 10022, this allows the Philippine Overseas Employment Administration or POEA to refuse to issue deployment permits to specific countries, effectively preventing migrant workers from traveling there. So for example, may giyera sa isang bansa, no, pwedeng i-stop ang pag-deploy ng mga kababayan natin sa bansang yon para sa kanilang kaligtasan. And we also have the Anti-Violence Against Women and Their Children Act of 2004. And under this law, the court may issue protection orders that restrict the movement of individuals against whom the order is intended. And then we also have the Inter-Country Adoption Act of 1995 or RA 8043. And under this, it allows the Inter-Country Adoption Board to issue rules restricting an adoptee's right to travel to protect the child from abuse, exploitation, trafficking, or sale. And then we also have the Mandatory Reporting of Notifiable Diseases and Health Events of Public Health Concerns Act or RA 11332 and the Executive Order 168. So this 11332, it authorizes the government to implement measures including travel restrictions to prevent the spread of notifiable diseases. And then the EO 16A created the Interagency Task Force for the Management of Emerging Infectious Diseases, which may recommend travel bans or restrictions during public health emergencies. So together, no, they allow the government to detect, respond, and control outbreaks effectively. And it is also important, guys, to distinguish between restriction on the constitutional right to travel and a mere regulation of movement. So for instance, itong OCA Circular number 49-2003, this requires judges and court personnel to obtain prior permission from the Supreme Court for foreign travel. And the court clarified or explained in the case of Inwino versus Honorable De Lima that this is not a restriction but rather a regulation of leave that is necessary for the orderly administration of justice. And this is a condition tied to the employment because the absence of judges and court personnel, no, may affect court function, but this OCA circular does not restrict the inherent constitutional right itself, okay? So example lang yan, okay, let's say court stenographers, no? One of the requirements para makakuha sila ng travel authority from SC is dapat may certification sila from their head of office na wala silang backlogs or kompleto ang mga TSN or transcriptions nila. So now, kung submitted for decision na ang case pero si Steno nag-travel na sa abroad na hindi niya pa pala natatapos ang TSN for that case na very important for judges in formulating their decision, so it will cause delay to the administration of justice, no? So or let's say si a client, no, palit siya ng lawyer and then the new lawyer needs to study the case, so kailangan niya makakuha ng copies ng mga TSN, pero si Steno andun sa Thailand, nagsakay-sakay pa sa mga elephant, no? So magkakaroon ng delay to the administration of justice. So ganito lang yan no? The judges and court personnel are required to secure a travel authority from the Supreme Court before we can travel abroad. But that does not mean, no, na we cannot travel without this travel authority, ha? Makaka-travel kami for sure. Makakalabas kami ng bansa for sure yan. This won't restrict us of our right to travel abroad, but there will be consequences pagbalik for not following the OCA circular. Para lang yang travel now, iyak later. And that concludes my discussion on liberty of abode and right to travel. So let's move forward empowered, knowing our rights, respecting the law, and walking the path of justice. Thank you, and may your journey always lead towards knowledge and liberty.